Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be discussing the importance of your lawyer having a strategy for dealing with termination and severance pay. Now, strategy is not simply reciting the law and court precedent. Being told what these aspects are is important, but by itself, it is not strategy. Because your former employer and their legal counsel do have a strategy. And that is to deny what you are putting forward. And by reciting this denial and keeping on pressing forward with it, they intend to make the legal process all the more time-consuming and expensive. And with an employee lawyer that does not have strategy, this can be extremely advantageous from the perspective of your former employer because it creates problems, it creates costs, and it extends out the period under which your legal suit is undertaken. But if your lawyer does have a strategy, if they do have a plan upon which they can pursue your legal action, then you have a fighting chance. And what does their strategy entail? Well, a couple of key principles. If your lawyer has a strategy, they can in fact make not selling with you more costly for your former employer. They can make it more problematic. They make employee relations an issue, creating unwanted publicity for your former employer. And they make that employer subject to increased scrutiny. Because the fact of the matter is, with a solid strategy, the claim is not merely about yourself, but it is expanded out to other employees. And you allow other employees to identify issues that whether they are consistent with your own, or more often than not, are even issues that do not pertain to yourself, but apply to themselves and create even greater problems for your former employer. And that is the value of strategy. Being able to bring out a situation that started off pertaining to yourself, but strategically expands out beyond yourself and makes the situation far more problematic, far more challenging, and far more costly for the employer, such that they do not want to deal with the situation. And if they understand that, they will want to settle with you, because that is a critical phenomenon of strategy. So make it a point to inquire about the strategy that your lawyer is looking to undertake and how the lawyer is going to leverage it to your advantage. You need to know what is the hook that the lawyer intends to work against your former employer's legal counsel and make it work to your advantage. This is absolutely critical to taking a lawsuit, taking legal action against your former employer. Because if you don't have that hook, if you don't have that legal strategy, you're simply flailing in the wind. But if you have the legal strategy, your lawyer needs to know it, and your lawyer needs to make you aware of it. Because when they can make you aware of it, they can then make the other side aware of it. And they might not recognize it at first, but once they recognize it, they will realize that there is a major issue that they have to contend with. And they're not simply going to have a former employee that's going to bend over backwards, but they're in for a legal fight that they need to find some way to deal with. And hence the importance of strategy from the outset. Your lawyer needs to have a strategic point to pursue and they need to be able to communicate to yourself, because even though the other side doesn't want to recognize it, the fact that you have it is going to be absolutely critical to the resolution of the situation that's been created by your former employer when you've been terminated, fired, or otherwise let go from your job. Thank you.